everyone. Thank you for your patience. Tonight, as I said earlier for my intro, the topic for tonight is looking at asylum seekers, whether or not they have a right to work whilst they are yet to receive decision on their applications. So if one seeks asylum because of various reasons, which I'm going to take my time to explain or to discuss, I'm going to take my time to give an update in terms of the statistics. I love statistics because it helps to give a clear picture, and then I can top it up with the law. So I'm going to give the statistics. Obviously, I also look at policies, in the streamlined policy that have been introduced and what it entails. And then moving further, I'll look at, most importantly, right to work. So I'm going to look at this topic in 3 areas. And therefore, I want you to bear with me, and if it's possible, invite a friend to invite a friend, and share the video so that everyone can benefit, because there are a lot of people out there who need some of these discussions so that they can be assisted in making informed choices. Because every problem, apart from medical problems we face in this world, has its root in law. Even medical problems, we do have law there. That's why we have clinical negligence. So a choice in this world impinges on law. That's why it's so important that most times we need to have some of these discussions so that people can be informed of their right, and obviously this can assist them in living their life free of fear. So tonight I'm looking at asylum seekers. Obviously, we all know that it's a very topical area of the law. There is no single day that you tune on your TV that you will not hear about asylum seekers on the boat. Obviously in Kent, and even if you listen to radio, you see here about this topical area of the immigration. So tonight I'm going to take my time to give background. Sometimes I get marveled when I hear people talking on the radio and making some frivolous submissions on issues that they have no clue what it's all about. Hey, tonight I'm here to give facts, not fiction. So guys, I want to urge you to share the link. I'll go on a short commercial break, because I'm going to do this. I'm going to make sure that my group, who are always willing to get this link, also get it and join me on this show. And whilst I go on this commercial break, it's an opportunity for you to look at what CITI Law Solicitors we've been doing, our areas of practice. It's not just the music and the background, but obviously I'm going to share the link, so I want to urge you to do the same. So please don't go away. Thank you so much for your patience. Yes, so once again, if you have just joined me, I'm discussing asylum tonight, and I'm looking at the right to work of asylum seekers whilst their application is still being decided or is still pending, or when they are yet to receive decision on their cases or applications. So that's what I'm going to discuss tonight. But I've already said that I'm going to look at both the statistics, the streamlined procedure, and helping to triangle down the backlog, and also go further, most importantly, to look at right to work, whether or not those who have been waiting endlessly or whose fate is in limbo and are facing a lot of hardships do have a right to work. And it's so important. As I was coming to this studio, I was reading an article where Midway Council has made efforts ferociously to refuse to provide accommodation to unaccompanied children, asylum seekers. So you can see that this is a very topical area. But it's important that we discuss it so that people know they are right, because that is what CITI Law Solicitors is here to help to inform the topic, to assist them in their legal choices. So that's why I'm here tonight. So to start with, I want to first look at the statistics. Currently, as I'm speaking, there are about 160,919 asylum applications which are pending. They are sitting there with the Home Office. A whooping figure of 1,069.19. So you see that this 160,999 applications, they are human beings that have made these applications, and they are still waiting. And some of them has waited for about 2 years. They say no decision that is forthcoming. And therefore, there are a lot of backlog. So the question is, why is it that, and if you look at this 160,919 applications that are still pending, between the year just 2022, only 18,900, approximately 19,000 applications that were completed. But obviously, about 76% of those applications were granted. So the success rate is very high. It means that these Africans are genuine asylum seekers who, in most cases, are fleeing persecution from the countries that they are coming from, either because of their political opinion, or in general, you say convention reasons. So that is the backlog, that is the figure, and that is the number that have been completed. So you realize that there are a lot of applications that will say be pending. We have some of the clients when they call almost every week to check on the progress of the application. Sometimes I feel very sad for them, because it is not something that is going to be decided within a matter of weeks or months. It's taking years. So you realize that clients become very impatient, and sometimes we receive the brunt of it. But in actual fact, the reality is that there is a backlog of 160,919 sitting there. Now, let me quickly digress or look at factors that has contributed to this backlog. Why is it that there are so many cases that only out of the 160,919, only 18,900, or approximately 19,000 cases that have been completed? Why? Now, if you look at the statistics, you realize that, one, there have been a lot of new arrivals. And these arrivals are people who are coming in to seek asylum. And the reason most of these people are coming is the fact that there are a lot of political instabilities, especially in the Middle East. So we have countries such as Yemen, we have Afghanistan, we have Libya, we have Eritrea. So we have some of these countries that are experiencing political instability. And due to that, most of them, because of their political opinion or convention reason, or because of their religious affiliation, they are forced to flee from persecution or being persecuted from the state or those who have taken power of these countries. And that is the reason why we have a lot of new arrivals. But of course, I don't want to be political because I'm here to talk about law. You realize that when we used to have the Brussels Convention, it means that if somebody went through a member state and was meant to come here or have sought asylum in another member state, then of course that person may be asked to go back, because if he has been successful in any member state, then obviously he has to return there. Or if you came through a safe member state, then you should have sought asylum there. And then Brexit came with all this stuff, and eventually people are coming in. But I don't want to sound political, because I know whenever I do some of these shows, there are those out there who make some comments. I'm here just to teach the law. Now, so having said up, discuss the new arrival, one of the reasons that has also contributed to the backlog is Home Office own policy, the Secretary of State's law, what we normally call inadmissibility, which means that sometimes when people have made an application, sought asylum, rather than Home Office considering those applications, what they seek to do is try to consider the admissibility of those applications and try to remove those people. Remember, Hotel Rwanda. Now, so you see that these applications, instead of being considered, the admissibility rule, when considering it, within a year or two, instead of the application being considered, Home Office will be making an effort to remove some of these applicants or asylum seekers under the admissibility grounds, which is another technical word that I don't want to bore you with these jargons. So you find out that not until Home Office have found a safe state to remove those applicants or asylum seekers to, they can't go. And you find out that out of about 81 people that were self-admissibility decisions, only about 20 were removed. But this admissibility rule in itself have immensely contributed to the backlog, because instead of applications being considered, resources are rather being used to enforce removal. That is quite elusive, because even with the High Court hasn't confirmed that people could be removed to Rwanda, Hotel Rwanda, there is still a problem, and this case is still being fought in court. So there is still legality issues that has almost made it impossible for people to be removed to Rwanda. So there are two reasons, namely new arrivals and Home Office own policy in terms of admissibility rules, which has contributed immensely to this backlog. So, having explained the figures, the factors contributing to these figures, the other point is look at the new streamline rule. So what is the new streamline rule? Rishi Sunak, the Prime Minister, has made a promise that he's going to make sure that asylum applications are decided, decisions are made within months, if not weeks. And therefore, currently, there are some countries, especially Yemen, Afghanistan, we have some clients from there, and then we have Libya, Eritrea. So some of these countries have as high as 95 success rate. It means that if 100 people coming from this group of countries seek asylum, about 95% of them are granted. So the streamlined policy introduced by Rishi Sunak is that instead of wasting time to conduct interviews, which most times cause a lot of delays, because sometimes people seek asylum, it takes even weeks, if not months, after they have gone through the screening, before they get the opportunity to attend an interview. Therefore, currently, people should listen attentively to this, especially if you are an asylum seeker. Normally, we know that we have the Nationality and Borders Act, which came into place June last year. So you realize that those who we call legacy cases, those who have sought this asylum before this date, most of them, instead of going for an interview, they may be sent just a questionnaire comprising about 50 questions. I remember many years when I came to this country, they used to have this questionnaire where people will be sent questionnaire, especially if you make further submission. You send a questionnaire to fill and then send it back to the Home Office, and a decision are made before they then decide to introduce this interview quite strictly. So they are going back to this questionnaire where people are sent questionnaires of about 50 questions to ascertain their nationality. They will check their criminality and all those factors. And they are given 20 working days, which is a calendar month, to fill it and submit it. So once they've done that, then there will be no need for them to go for an interview. So if you have just joined me tonight, I know that sometimes it can be very boring because I like giving a lot of statistics. So if you have just joined me, I'm obviously discussing asylum and how people can have the right to work if they seek an asylum. So I've looked at the statistics, I've looked at the streamlined policy, which is obviously going to assist to draw down the figures, which is to make sure that the backlog is cleared, especially those who have put in applications before the Borders and Nationality Act came into force. So you have these legacy cases being dealt with in terms of being sent questionnaires to fill. And once these questionnaires have been completed, they don't have the need to go for an interview. So that is the new streamlined policy. And this group of countries, for example, that I've just already explained, who have very high success rate, they are also going to benefit from this form of questionnaires. But having said that, you realize that there is modern slavery, there is also trafficking. These are areas that I will obviously take my time to discuss with time because there are a lot of cases where people have been subjected to some treatment which amounts to slavery, and or some people who have been trafficked one way or the other, who are also allowed to seek asylum or to seek refugee status in order to get protection. So that is also another area, but I'm not here to go into that. So having given this background, having established that there are cases that have been pending for almost 2 years, and for that reason, most of these people, obviously, when they seek asylum, they are asked not to work because they don't have the right to work. And why is it that asylum seekers are not given right to work when they seek asylum? The reason being that they don't want asylum seekers to have adverse effect in competition with those with settled status or British because of the fact that if they were given the right to work instantly, then there is what they call economic migrants, because they have some of these asylum seekers that they have been categorized as economic migrants, and that's one of the reasons why this admissibility policy was introduced, to seek to remove those whom the Secretary of State might consider them to be economic migrants, and therefore these people are obviously all efforts are made to remove them to a safe state, which is one of them is Rwanda. So, due to this backlog, due to this delay, and the fact that these people don't have the right to work, it becomes quite frustrating for most of these asylum seekers. Because waiting for 2 years without having right to work can be very frustrating, because some of them, they may, even though they are seeking protection, they may still have family members who are dependent on them abroad. And sometimes they need to make some financial remittances to support them. And therefore not being able to work becomes very catastrophic for them and their families. So, coming back to my main topic, do you then have the right to work as an asylum seeker? That is the question that I want to answer. And once I've answered this question, I will obviously seek to come to some final stage of my submission tonight. So what I've been doing, for those of you who have just joined me, I've been looking at the statistics of asylum seekers, why there is so much backlog. And obviously it's quite a broad area, so I'm not going to be able to touch on everything. The new streamline policy that has been introduced. And now I'm looking at right to work. Do you have right to work as an asylum seeker? I know most of you will say no. And many times there are a lot of asylum seekers. I remember when I was training one of my principals, you have this food voucher, and we have these asylum seekers who are always coming in to collect some of these vouchers and go to the food bank to get some food for themselves. And some of them having waited for more than a year, they are so cash strapped and they don't know their right, and therefore they tend to struggle because they are not able to work because they didn't know they have that right. And it is that right that I want to discuss tonight. So, normally when you're an asylum seeker, you don't have a right to work. However, there is a law that allows you to have right to work. And this law is in the immigration rules. And that's what I'm going to expose to people tonight. So in the UK, if you don't have right to work, or you don't have right of abode, then there are two sources of law that you could find your right to work enshrined in. One is the 1971 Immigration Act. And two is paragraph 360 of the immigration rules. I don't want to bore you with all these legal jargons, but it's important that I speak facts on this platform. That is the distinction that I seek to make most times when I'm here, so that people can be assisted with the facts and they know that they have accurate sources for whatever they are seeking to do. So you find out that if you look at the paragraph 360 of the immigration rules, and I quote, if one has made an application for asylum, or application has been made by an individual that they want to seek asylum, either because one, they are lesbian or gay and they are coming from either Ghana or Nigeria, where they can be persecuted, or because they are Christians and they can't live in Afghanistan because of their religious belief or because they have some political opinion that was associated with the previous regime before the Taliban took over and they're coming from Afghanistan, or they are members of a particular social group. And in this case, I'm looking at the convention grounds for seeking asylum. So when one has sought asylum on these grounds, then you find out that within the first year, they don't have right to work. However, after a year of the application having been delayed with the Home Office, and this is the reason why I started by giving the statistics and then explaining the backlog and how long people have been waiting for decisions on the asylum applications, which on average is about 2 years now. This is the average time span that one will have to wait for a decision. So after the first year, if you look at the paragraph 360 of the immigration rules, if one is recorded as an asylum seeker a year from the date that he or she was recorded as an asylum seeker, a year after, that person has a right to apply for a right to work. And the Secretary of State, in this case, Home Office, must give that person right to work, provided the delay of that asylum application is not that person's own doing. So here, let me take my time to explain it properly, because there are many of you out there who maybe you claim you are lesbians, maybe you claim you are gay, maybe you claim because you are coming from Islamic country and you are Christian, maybe you claim because you have been trafficked, maybe you claim because you have some political opinion completely opposite to the regime that is in power. And for that reason, you are here waiting for a decision and your fate is in limbo. You do have a right to work. So in this case, if you look quite carefully at the paragraph 360, as long as your application has been pending for a year or more, and on average people wait for 2 years before they get decisions. And as long as that delay is not your own doing, it means that if, for example, you went for an interview and then the caseworker asks you to provide further evidence to establish your nationality, your age, your paternity, your maternity, and you have complied with those directions, and the delay resulting from the asylum application is not your own doing. It's not because you have failed to comply with any of the directions. Then a year after you've been recorded as asylum seeker, either because you're lesbian, gay, or whatever it is that you claim to have been trafficked, you do have the right to do what? To apply for right to work under paragraph 360 of the immigration rules. And once that application is made to the Secretary of State, in this case, Home Office, so you need to actually make an application. It's not an automatic right. And once the application has been made, it will be considered. And once this application has been considered and it's not your own doing, Home Office or the Secretaries have no right to deny you that right to work. And this has been established by the case of Romanata versus the Secretary of State 2000, as far back as 2013. So it's been almost 10 years that this case law has been in place, emphasizing the fact that asylum seekers do have right to work. Now, so what sort of work do these people, or can they do? I must admit that there are restrictions here. Now, the work you can do, you cannot be self-employed. That's number one. Number two, you cannot also set up your own business as an asylum seeker whilst your application is pending, but more than 1 year from the date of your application, and you have so decided to apply for right to work. So under those circumstances, you realize that though you be granted right to work, but you are restricted from setting up your own business. You're also restricted from being self-employed. But in a very restrictive sense, you are also restricted from only taking up jobs in the shortage occupation area. Now, so you realize that the shortage occupation list is always monitored and updated. Last time I was here to explain to viewers that the care worker visa route, which is 6145 as ordinary carers, was not going to be abolished. And quite clearly, it is still in force. That is one of the shortage occupation areas. So these asylum seekers have the right to work in the care industry. Now, those who have medical background, those who are engineers, those who are welders, there are various lists of shortage occupation jobs that any asylum seeker who has been granted right to work can work in these areas. So these are the areas that those who have been granted right to work after waiting more than a year of their case or the application do have right to work. Right, so tonight I've had the opportunity to discuss your right to work. At this point, I want to take a few minutes to advertise our sponsor. Obviously, I cannot, I will be dismissed if I don't advertise our sponsor because they are the sponsors of this show. So I'm going to take my time. I have a few people watching tonight. I have Steve Asabeko, it's a well done, senior most barrister. Keep soldiering on good humanity. Thank you. I have Sophia Sean, I have Ernestina Kari, who is also watching. Guys, if you are watching, you can obviously make a comment, and then I'll be able to acknowledge you. I love to acknowledge you guys who have spent your special time to join us tonight on this platform. So at this point, I'm going to take a few minutes of your time to advertise our sponsor. This program is proudly sponsored by CITI Solicitors. CITI Solicitors is a law firm well established. You can find us at Barking. Our office address is Unit 113 122 Barking Enterprise Center, 50 Cambridge Road, Barking, IG 11 8FG. Our office number is 02033550782. I repeat, 02033550782. That is the office number. So guys, take it down. Right. If you want to visit us for consultation, there are a lot of, if you are coming from Canning Town area, you can jump on the bus 5. It just en route right from in front of the office to the parking station. Those of you coming from Romford area, you can also jump on the bus 5. If you are coming from North London, I always say that it's so easy to come from North London, because if you go to the South Tottenham train station, there is a train that comes from Gospel all the way to Barking as the last stop. And if you are coming from the city, if for whatever, those of you who normally come from Glasgow, Edinburgh, Manchester. We do acknowledge all you guys who travel afar to come to City Law. So if you get to Easton, we have the Hammersmith and City line coming straight to Barking. And then if you want to also take either Central line, Jubilee line, and C2C, those of you coming from SS, Basildon, Southend and C. In fact, it is a very nodal point where you can't mix it. All the trains are coming through there. So if you want to visit us, those are the trains that can assist you to come. Now, why will you want to visit? Because we specialize in numerous areas of law. I always say that City Law Solicitors is a one-stop. One-stop in the sense that most of the areas of law that we discuss on this platform are the areas that we also practice. And therefore, if for whatever reason you want to, whilst advertising, if anybody has any question, you can also ask. So at this point, if you have just joined me, I've discussed Asylum. I'm going to give a summary. But in the meantime, I'm advertising our sponsor. So we are one stop because we specialize in numerous areas of law, and notably immigration. Immigration is our hobby, and most of you who have had the opportunity to use our service, you can testify to it. So we specialize in all the immigration rules. We also assist companies to get sponsorship licenses to be able to bring people from abroad to fill especially jobs in the shortage occupation, being those who want to bring priests as a church, those who want to have care companies and they want to get licenses to bring people abroad to come and assist them to flourish their business. If you want to bring your wife, children, if you want to say make late application under the EU settlement scheme, if you want to, you have sought asylum and you need assistance, we have clients from Afghanistan and those from various nationalities. So we can also assist you in these areas of the law under immigration. Nationality, if you want to naturalize, we can assist you as well. So we specialize in all areas under the immigration is very, very broad. Right. Employment, if you have been dismissed from work, if for whatever reason you've been bullied, you have suffered discrimination at the workplace, we can also assist you in dealing with your matter. And most of these cases are no way, no fee. Personal injury and clinical negligence. If you ever had an accident that was not your fault and you want us to assist you, we will also be willing to assist you on those bases. If you went to hospital and you had a procedure, or what people normally call surgery, or whatever treatment you receive, and for whatever reason, there has been clinical negligence, which means that you've not been treated properly, that a doctor in the same line of duty will not have used that procedure and there is a problem, then of course that is what we normally call clinical negligence. We can also assist you, it's no way, no fee. And we also specialize in family law. If you are not having contact with your children because their family has fallen apart, you need to protect the best interests of those children. So if one of the families is not allowing you to do that, we can assist you with child arrangement order. If you want to put in place cohabitation agreement to secure interest in the relationship, we will assist you. And for those of you who are tired of your relationship and sadly you are going through divorce, we can also assist you with your family matter. Commercial dispute and civil litigation. If someone is owing you, doesn't want to pay, we can also assist you in this area of the law. Housing law, if you are in accommodation that is in a disrepair state, again, this is no way, no fee, we can also assist you. Consumer law and media and entertainment, we are also here. If the insurance company is failing to pay you your compensation, we are here to assist you. So guys, this is why I always say that City Law Services is one stop, because we are here to assess businesses and individuals, either their family matters, immigration, employment, personal injury, clinical negligence, housing. So you name it, we cover all grounds. So It's been amazing having you tonight. And if any of you have missed part of this program, or you find it very exciting and insightful and educative, you can obviously continue to watch it even after I've left here. If you didn't have the chance to watch whilst I started the show, you can still watch it again and again, because this program stays on all our social media channels permanently, either the YouTube channel, my Facebook profile, Thomas Berber, or City Law, City Media TV on Facebook, or City Law Solicitors Facebook page. You can still continue to watch these shows, and you can watch it again and again. I must say that everything that I have discussed here is for guidance only, and I always urge you to seek proper legal advice if you want to obviously proceed on any of these matters. City Law Solicitors does not take responsibility for anything that has been said here. But in any case, this is the reason why we are here. If you need assistance, we'll be here to assist. So I want to thank all of you for, I have Apasikpana John Amakwanya. If I have not pronounced your name properly, I'm so sorry. I think this is the first time you've joined us. God bless you. We do this show every Tuesday in English, and then Wednesday, the famous MC Chaka, who is the show in Tree. So tomorrow, by the same time, I'm going to be here with MC Chaka, and then it will be privileged to have interaction with you guys out there. Even after I've left, you can still share the show for your friends and family members to benefit. God bless you. God bless you.